Hi students, today we will discuss Unit 3 of Chapter 2, which is Essential Elements of a Contract. So there are four subtopics we need to discuss. One is capacity to a contract or competent parties to enter into a contract. Second is free consent. When these parties enter into a contract, the consent given by both the parties has to be free, and the activities and the consideration which these parties are going to carry out has to be lawful. And fourth, we have the certain contracts, certain agreements are expressly declared as void as per Contract Act. Make sure that the contracts entered between these parties should not be in this negative list. So we can call them as negative list. So first we'll start with capacity or competent parties to enter into a contract. So every person is competent to enter into a contract who has attained the age of majority. A person who has completed 18 years of age, who has not entered, who has completed 18 years of age, we call him as major, and he is competent to enter into a contract. The person who has not attained the age of, attained the majority, that means who has not completed 18 years of age, we call him as minor. A contract with minor is void ab initio. It is void from the very beginning itself. Next, we are having unsound mind, people who are unsound mind. And thirdly, we have persons who are disqualified from contracting by any law. By any law. So they are disqualified from the perspective of law. Okay. We'll discuss each topic in detail. With respect to minority, we'll cover after 5 minutes in the next slide, where we have discussed 15 aspects of minors. Okay. 15 aspects of law which is relating to minor or position of minor. Unsound mind. Who is unsound mind? A person who is not, who is in a position to understand the terms and conditions, and who is able to understand the effects of those terms and conditions while entering into a contract. We call him as sound mind. Unsound mind is who is not in a position to understand the terms and conditions and its effects. Let us take an example. A person who is in a drunken stage, who is consumed drugs. So is he in a position to understand the terms and conditions? The answer is no. So then we call him as unsound mind. There are few patients who are not in a position to understand the terms, who are not in a position to understand the effects of those terms and conditions uh, in which they are entering into a contract. Those people we call it as unsound mind. So who is a sound mind? A person who is capable of understanding the terms and conditions, forming a rational judgment as to its effects upon its interests. Let us say a person fully sound mind, he is competent to enter into a contract. A person who is fully unsound mind is incompetent and it is void. Let us say there are people who are occasionally sound mind or occasionally unsound mind. At that scenario, in those scenarios, when the person is competent, or when the person is said to be competent, is the person when he is of sound mind. So occasionally he is sound mind, then when he is of sound mind. Let us say occasionally he is unsound mind, then he is not competent to enter into a contract. Then there are disqualified by law. Who are all the people who are disqualified by law? Let us say there is a alien enemy. Alien enemy. Let us say China is having a war with India. Now all the citizens of China will become enemies to all the citizens of India. So Indian persons, Indian companies, Indian traders cannot enter into a contract with Chinese people or Chinese organizations. So all the Chinese citizens, Chinese organizations will become alien enemy. The reason being, if you pay some consideration to Chinese corporations, that money directly or indirectly can contribute to the war. So next, convicts, prisoners, people who are in jail, they are also incompetent to make a contract. Persons who are insolvent, they are already declared insolvent, they are also incompetent to contract. they became insolvent because they could not able to give their consideration to other parties. They could not able to pay their debt with the available assets which they have. So they became incompetent. They became insolvent. Now, a new contract with a new consideration, can they able to pay? They may not able to pay from the eyes of law. So they are insolvent. They are incompetent. Corporations or companies. Companies are bound by their objects clause in MOA. We will discuss this in detail when we are discussing Companies Act. So company as an artificial person can be able to enter into contracts which are mentioned in their objects clause. Any contract which are entered against or beyond the object clause is void. So corporations has limitations to enter into contracts, so that we'll discuss in detail when we discuss Companies Act, the objects clause. Foreign souvenirs and ambassadors. Foreign souvenir and their representatives. The ambassadors are none other than the representative of foreign souvenirs. So what is the difference between foreigner and foreign souvenir? So foreign souvenir is like a head of the state, president of France, king of Dubai. So these people has immunity. These people has immunity. So if they make any contract, let us say Queen of England. Queen of England, she came India, she made a tour to India, she bought a picture. She bought a picture in the art gallery. She took the picture along with her, and now she is not willing to pay the money. Can you go to court of law? Which court of law? Some Indian court. You cannot go to any Indian court for such foreign against such foreign sovereign, because she is the Queen of England, and you cannot call her and you cannot punish her. You cannot sue for her damages. So foreign sovereigns, not foreigners. Foreigners are like, you can make a contract with foreigners and you can also go for justice in Indian courts, but in case of foreign sovereigns, enter, you cannot make a contract. They are incompetent to enter into a contract. And such as ambassadors are representative of foreign sovereigns. So these are the people, the alien enemy, the convicts, the insolvents, and companies or corporations, foreign sovereigns and ambassadors. These are the people who are made incompetent, made disqualified by the law itself. Because of their status, they become disqualified and they become incompetent to enter into a contract. So there are three topics in capacity. One is majority, the person who attained majority, the person who is of sound mind, and the persons who are not disqualified. This is also a negative list. So you need to, while entering into a contract, the people should be taking care that they are not entering into contract with these people. So let us discuss about minors in detail. So in case of minor, so as we have discussed, a minor is incompetent to enter into a contract, and the contract entered with minor becomes void ab initio. It is void from the very beginning itself. So let us say a minor, the activities which minor has done, let us say he borrowed some money from some person. So can this will be binding on their parents, binding on their guardians? No. The answer is clear cut no. So only in case where the parents are in present and they agreed for that. So in absence of their parents, if a minor make any contract, if a minor make any activity, it will not be binding on their parents unless they agree. Unless they agree. So generally the answer is no. Next, a minor along with his adult, a minor along with his brother who is an adult, who is a major, if they make a contract, if they enter into a contract, then minor is not liable, major is liable for that contract. A person, let us say, has a guardian, a minor who has a guardian. Now, can he enter the guardian on behalf of minor? Can he enter a guardian who is a major on behalf of minor? Can he enter into a contract? The answer is yes, but the contract has to be beneficial for the minor. It should not be loss making. It should be beneficial for the minor. And the guardian can be appointed by the court of law. In few cases, a guardian can be appointed by the court of law for selling their minor's property. For selling the minor's property, then also the guardian is eligible to enter into contract on minor behalf for sale of minor's estate, minor's property. Then we have surety or guarantor. Surety or guarantor. So a person who is major, can he give guarantee against minor? Yes, he can give. And in this case, he directly get involved in the contract, and the other party knows the surety or guarantor. Hence, he is liable but not minor. So we can remember like, so minor. So first parents, if he lost parents, then his brother. If he lost his brother, then guardian or uncle. If he lost his uncle, then you can think of his parents' friend who acts as a surety or guarantor. As a story, you can remember these 5 points. Next, let us say he or she may become an age of 15 or 16 or 17. He became little naughty or mischievous. Then he made a fraud. He himself telling to people that he is a major and he is entering into a contracts. He took loan of 1 lakh from other party, telling them that he is a major. So post receipt of money, can he plead minority? Can he say he is minor and he makes the contract void? Yes, he can make the contract void. He can always plead minority. He can always come back and say, I am minor, I am incompetent. The contract entered between them is void. Let us say that 1 lakh which he has received, he spent that money and he don't have any property, he don't have any assets to repay that money. That 1 lakh is lost. So he can always plead minority. Then let us say liability for tort. He borrowed horse from his neighbor. He borrowed his horse from his neighbor and he gave it to his friend. His friend jumped, kicked, beaten that horse to death. Beaten that horse to death. So this we call it as liability for tort. So in case of liability for tort, the minor is liable to the extent of his property. To the extent of his property. Liability for necessaries. So a minor was supplied with necessaries. If a person who supplied necessaries to minor, then he is eligible to recover those amounts, recover that money from the minor's property, to the extent of his available property. Can we ask for any specific performance? We cannot ask for specific performance. The reason being the contract entered with minor is void from the beginning itself. You cannot ask for any performance. You cannot ask for any activity from the minor because it is void ab initio. We cannot ask any performance from the minor. Last, so liability for tort, liability for necessaries. Let us say he took some money. Can he repay that money to the extent of his property? Yes. But beyond that, he will not become insolvent. Minor cannot become insolvent. Let us say with all these negative things, he became a good person and he now acting as an agent. Can he act as an agent? The answer is yes. He can act as, like, he can draw a check, he can do some activities on behalf of major, but the liability goes on to the principal who is major, but not on the agent who is minor. Can he become beneficiary? Yes, he can become beneficiary in any of the contracts we have already discussed. A guardian, he enters into a contract. He enters into a contract on behalf of minor, which is beneficial to the minor. Yes, he can become a beneficiary in any sense. Let us say their parents, they place nominee as their children. So children are minor, but in case of unforeseen scenario, the money will be paid to beneficiary who is the minor. He can also become a beneficiary. He can become an agent. He can become a beneficiary. Can he become a shareholder? He cannot become a shareholder. But let us say the guardian or the parent, they hold some shares through transfer or through transmission. They can they can give those shares to minor once he attains majority. Once he attains majority. So let us take an example. Parents who are wealthy, they died, they hold certain shares. Now minor cannot become a shareholder. So on behalf of shareholder, guardian holds those shares. Once the minor attains majority, the guardian can transfer those shares to the person, the major who was previously minor. So can minor become shareholder? The answer is no. But can he be beneficiary? Can he be taking those shares at a later point in time as transfer or transmission? Yes. What is transfer? Voluntarily, if guardian is transferring those shares, we call it as transfer. Let us say the case is with in the court of law. Court, through law, if shares has to be transferred, we call it as transmission of shares. Next, can he become a partner? The answer is yes, provided all the major partners gave their consent to make minor as a partner for the benefits, not for the losses, only for the benefits, only for the profits. Then he can become a partner, provided all the partners have agreed for that. And also provided that he became partner for the profits, not for the losses. Finally, all these activities, what he has done as minor, the liability which you got, can you ratify that? We cannot ratify after attaining majority. So any act which was done in minor, when he is minor, can he ratify? We cannot ratify. Ratification after attaining majority is not possible, is not allowed. So these are the 15 scenarios you can remember like a story. The first 5 parts are like when he's taking care with parents, when he's taking care with his brother, adult, uncle, or surety or guarantor. When he lost everyone, then he did some frauds, he was needing some money for necessaries, he was doing some mischievous or naughty things, and he's not doing anything. Finally, he cannot become insolvent after doing all these such things. He is liable to the extent of his property. For the purpose of only necessaries and tort, he can be make liable, not for any other thing. Then he learned the lessons from the nature, he learned lessons from the market, and then he became a good individual. He became a good individual, good and nice individual. Then he became agent, then became beneficiary. Also, he became a partner. So can he ratify after making majority? No. So these are the 15 topics or 15 things you need to remember. This can be forming part of a case law. It will not be asked directly. Generally, it will not be asked directly. It will be asked in a case law form. Then you should be able to recollect these 15 aspects, 15 cases, and you should be able to present your answer. This is with regard to competency or capacity of the contract. Next, we'll move to, out of 4 essentials, we'll move to free consent. What is free consent? The parties who are entering into a contract, they should give their consent, they should give their acceptance in a free manner, in free, not from any pressure, not from any pressure. So consent is not free. When consent is not free, in these 5 scenarios, what are those? Coercion, undue influence, fraud, misrepresentation, and mistake. So the numbers which were mentioned before this are the section numbers of Indian Contract Act 1872. Section 15, Section 16, Section 17, Section 18, Section 20, 21, and 22 deals with these activities, these aspects, which are coercion, undue influence, fraud, misrepresentation, and mistake. Let us say a contract was made with the first 4 aspects, which is from coercion to misrepresentation, it becomes voidable. The contract becomes voidable. Whereas if it is done through mistake, the contract becomes void. The contract becomes void. So if it is done through the first 4 aspects, it is voidable. The 5th aspect is void. Clear? Next. So we will discuss each aspects in detail. What is coercion? What is coercion? We'll first discuss the definition of coercion. So let us say there is a person who is committing or who is threatening to commit, who is committing or who is threatening to commit any act which is forbidden by law, which is forbidden as per Indian Penal Code. So let us say a person is beating another person or threatening to beat. A person kidnapped a child or threatening to kidnap a child. A person is doing theft or threatening to do theft. All these are examples, all these are the activities which are forbidden by law, which are prohibited by law, which are prohibited in Indian Penal Code. So these are the acts. If someone is committing or threatening to commit these acts, we call it as coercion. Why is he? Why is the person doing these activities? To influence or to induce the other person to enter into a contract, to make other person enter into a contract. So person A calls person B and threatens to kidnap his child in order to enter into a contract, now this arrangement we call it as coercion. So B is forced to enter into a contract because of coercion. So it is not free consent, he is forced to enter into a contract because of coercion. This is one example. Second example, unlawful detaining unlawful detaining or threatening to detain any property. Unlawful detaining or threatening to detain any property. Let us say you hold books of accounts of one client. Now you are telling unless and until they pay you money, you will not give their books of accounts. You hold jewelry of one person. A holds jewelry of one person. Now you are telling you will not give gold unless and until you get some money from that party. So that is the property belonging to some other. You are holding it for some specific purpose. Now you are detaining. Now you are holding. Now you are telling you will not give that property. You will not give that asset to other party. Unlawfully, you are keeping that property with you or threatening to keep that property with you. Then we said to be this said to be called as coercion. So these are the two aspects or two parts of the definition. One is any act, whether it's committed or threatening to commit, which is forbidden by law or prohibited as per Indian Penal Code, is coercion. Second part is unlawful detaining, unlawful holding, or threatening to detain any property. We also call that as coercion. Let us see the definition. So committing or threatening to commit, present or future, any act forbidden by Indian Penal Code, unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention to cause any person to enter into an agreement, then we call it as coercion. So then once we know the coercion, what are the effects? The effects is a contract entered with induced by coercion is voidable. Voidable at the option of the party where consent was so obtained. So in case of A and B, B got threatened by A. B got threatened by A. Now the contract becomes contract between A and B becomes voidable only and only if B agrees to make good about the contract, then it becomes valid. Otherwise, it becomes void. So he can cancel the contract. B, at his interest, can cancel the contract, can ratify or can make the contract good only at the consent of B, right? Consent was so obtained. The person to whom money has been paid or anything delivered under coercion must repay or return it. So you need to reverse the transaction. Let us say with the coercion, you collected some money that has to be repaid. This is the effect of coercion. Once you enter into a contract which is induced by coercion, then the contract is said to be voidable at the option of the party who was given the consent, with that coercion. And then the transaction, let us say you paid some money, you did some activity, you need to reverse that activity. You need to repay or return it. Next, suicide. Special case, suicide. So suicide is an act which is forbidden by Indian Penal Code. Suicide is a crime. Suicide is a crime which is act forbidden, which is act prohibited by Indian Penal Code. So Indian Penal Code prohibits suicide. So a person who committed suicide, so he will be no more, then there is no concept of contract in that case. However, a person who threatens to commit suicide. So A wants to commit suicide, and he wants B to enter into a contract. He wants to be enter into contract. Can this be called as coercion? The answer is yes. So in case of threatening to commit suicide is also regarded as coercion.